So, Mr. Ortiz, you must understand our dilemma. You're a very high risk, right? Given that it's your third gun conviction, you were on probation at the time for a robbery first. You know, these tickets are very serious, but we want to recognize that it sounds like you're on the right path. You have some new insight. You've grown and matured while you're in there.
Okay, and we are about to watch the parole journey of a man who just can't stay out of trouble, but given chance after chance after chance until finally they said, you know what, you're going to have to do some time in prison. And while in prison, he again can't stay out of trouble. But let's see what the parole board does and how this works out for him. So with that, let's jump in.
Good morning, everybody. Good morning.
Can you please state your name and inmate number for the record, please?
Bing Ortiz, 377642.
Thank you. This hearing is being conducted in consideration of the parole application for Bing Ortiz, inmate number 377642. He is serving a sentence of 5 years, suspended after 3 years, with 3 years special parole, 3 years probation, and 1 day conditional prison for stealing a firearm, possession of a firearm, running from the police, weapon in a motor vehicle, criminal mischief, violation of protective order, reckless endangerment, assault on public safety personnel, violation of probation, robbery first is the underlying offense. As of today, records reflect a parole eligibility date of February 22nd, 2024. There is no victim input in the case. There is an offender accountability plan. It has been reviewed, shows that he has completed anger management, is currently participating in the domestic violence program. Utilizing the statewide collaborative offender risk evaluation system scores, the offender's overall risk recidivating falls within a very high range. Mr. Ortiz, this is your chance to tell the board why you believe you should be granted parole. You may begin.
Okay, I wrote something down. It ain't that long. It's one page, one front of the page. I said, I contemplated about doing this extempore, but thought it prudent to write something down. During this period of incarceration for me, I have learned so much. I've read books that have changed my life. I finally gave medication a chance, and the positive effects have been copious. I now can sit down and focus and read, and in doing this, the light of education has revealed to me my faulty, ignorant, and selfish ways. I have learned the meaning of virtue and how important it is to have it. All my life, I've had dreams, but never really did the footwork to merit attaining them. Previously, I saw no problem with lying, not keeping my word, and not paying my debts. In other words, I was a cancer to society. I honestly thought I was unique. I now see that if I ever want to be anything, I have to be a man of my word, honest, hardworking, even in the lowliest job. I must implement long-term goals. I'm now a firm believer in moderation. The most important change to me during this incarceration is me becoming a Catholic. To live with Catholic morals and beliefs is to treat everyone with respect and fairness, never to take advantage or to lie. The books that I've read were at first too arduous to peruse. I couldn't understand the words. I was resolute and started looking up the words and writing down the definitions. The benefits from reading these books were bountiful. I've completed anger management and am almost done with DV groups. I'm being completely transparent, and this is why I put down that I don't have any stable place to live and really need halfway house services. I don't have much time left on this sentence. With good time, I say I EOS at the end of May. I had trepidation on how I will stay above float. The sooner I can get into a halfway house, the better, so I can try and build a firm foundation. Regardless, I'm prepared to embrace poverty until I can work my way up from the bottom. Whatever is the decision today, I'm okay with, and thank you for letting me speak.
All right. Thank you, Mr. Ortiz, for your statement. We have questions for you, okay? When we're done, we'll deliberate and give you our decision today.
Okay.
And we'll begin with my colleague, Mr. Cole.
Thank you, Madam Chair. Good morning, Mr. Ortiz.
Good morning, sir.
So, we're dealing with, like you said, the end of May, first week in June, right?
Mhm.
Is the end of sentence.
Yes.
You know that you have special parole to follow.
Yes.
And it's within our power to give you halfway house, so that you can start off and things like that, right?
Yes.
So when we're looking at this case, the offenses that got you here, really concerning, right?
Yes.
Right. And I really appreciate this piece. The DRs, the most recent DRs, which go back 2 years, right?
Yes.
which you've been doing well
Mhm.
with what you've been talking about, right?
Yes,
What you just talked about, how you got yourself stabilized and stuff like that, right?
yes,
But the DRs that are there are really concerned, right?
yes.
Okay.
Yes,
So I say that, but I also want to acknowledge what you said, right? Because I can see it. You're at that place where you're trying, you want to change and things like that, right?
yes, yes,
What I identified when you had the interview with the parole officer, you talked about halfway house. You talked about continuing to get clinical support,
yes,
right?
yes,
Which is really positive, right?
yes.
And have you done that out there before?
I've done certain programs that probation mandated that I had to do, but I haven't did AA and things like that, which I want to
Okay.
do now.
But right now, you go to the infirmary on a regular basis, right?
The infirmary.
The med line.
So, oh yes, yes. I take
Okay.
meds.
So what I'm trying to dance around that because we're public. Okay, so I'm trying not to get into your business.
Okay.
So when you get out into the community, have you ever been in a situation where you've done that as well?
No, this is the first for me with medication, but I do have family who say that they're going to help me as far as what I need to do to perpetuate me taking meds.
And that's a good thing, right?
Yes,
So you and you also talked about you want to do AA, NA, that kind of thing, right?
yes, yes,
All right. So that's again putting yourself around positive people, doing positive things in the community, right?
yes,
Will allow you to get into and start doing what you need to be doing, right? You're only what, 31,
yes,
right? So there's the 20s are over, right?
definitely, yeah.
So you've done you're in DV right now in there, right?
Yes.
And
Yes.
how's that going for you?
It's going well. I got 6 more sessions left.
Okay. And you also took anger management, right?
Yes,
And so did that give you some alternatives?
yes, and it made me more aware. And I to write down my coping skills and things I need to try to do when I'm placed in a situation where I can't get angry.
Okay. And what you're taking and also the thought process that you're learning is helping you with that?
Yes, that coupled with with learning so much, reading about anger and the effects that it has, the education has really changed my outlook on how I react to anger. Because I used to be selfish. Now I try to think about other people.
So they helped you find that window
Yes,
where you can make a decision on how you're going to proceed with whatever you're presented with in life, right?
yes,
That's a big thing, right?
yeah. It's been life changing for me.
Because when we don't look for that window, we wind up back in prison. And we don't want
Yes.
that happen.
I
Right?
agree. Yes,
So based upon all of this, you're headed in the right direction.
thank you.
We really want you to do well. And I just I'm going to see if other board members have questions for you this morning.
All right, thank you.
Thank you, Mr. Paul. So, Mr. Ortiz, you must understand our dilemma. You're very high risk, right? Given
Yes,
that it's your
yes.
third gun conviction, you were on
Yes.
probation at the time for a robbery first.
Yes,
These tickets are very serious, but we want to recognize that it sounds like you're on the right path. You have some new insight. You've grown and matured while you're in there. As you
Yes.
stated, you have a little over 3 months left. And then you
Yes.
could go to a halfway house, get yourself a job, start saving money so that you can be prepared and be successful when you hit the community, right?
yes,
I wish you the best, sir. Ms. Chance.
thank you.
I have no question, but I think.
All right. I think we covered it, Mr. Paul.
Absolutely.
Yeah.
So, Madam Chair, so Mr. Ortiz is doing well right now.
Yes.
he's got, last week in May, first week in June is
Yeah.
when he's going to end of the sentence, and he's going to go to special parole.
Yeah.
Halfway house is important.
Right.
I really want to see him do well, but the offenses here and the tickets that happen,
Right.
although he's made a major turn, it's like the 4 months, I can't
Yeah.
support the discretionary piece,
Yeah.
but I want to set him up so that he can do well in the community when he gets out here in a couple months.
Agreed. Anything to add, Ms. Chance?
Yeah, I think for the amount of time that he has left, that, a high risk for him was not being able to support himself. So during that period, I'd like to see him really look at, where he's going to get a job, because that was a pretty high risk for him. And I would like to see him complete the DV, so
Yeah.
the remaining time he can focus on a good release plan.
Okay. Thank you. In the matter of Bing Ortiz, inmate number 377642, I'll make a motion to deny parole due to the nature and circumstance of the offenses committed while on probation, and poor institutional adjustment. Anything else you'd like to add? Okay. And we'll set special parole conditions. You have 3 years of special parole to follow. Halfway house placement, no contact with your victim initials BG without your parole officer's permission. I know you have a child together, but get your parole officer's permission, okay?
Okay.
No contact with your co-defendant Carlos Lopez.
Okay.
No driving without your parole officer's permission. You don't have a license, suspended, right? So you have to get that straightened out, add it to your list. Domestic violence in the community, it's a continuation of the program that you're in right now that you'll finish soon. And mental health evaluation and treatment if it's deemed necessary.
Right.
Anything further? All in favor?
Aye.
Aye. This is a lot, and you'll get it all in writing, but we
Okay.
want you to stay, finish out the DV program, start working on your release plan. Then you'll go to a halfway house. You can get a job, start saving money, do some programs, and you'll be successful, right?
Yes.
Good luck to
I
you,
have
sir.
one question.
Yeah.
I have one question.
Yeah.
So if, when I finish the DV classes, the DOC, they do halfway house. Will they halfway house me?
Are you halfway house proof?
Yes.
Oh,
Well,
then they
no,
can.
I'm not approved, but I'm pending DV. Once
You're
I finish
pending
that,
DV. So
Yes.
keep working, get a good evaluation, excellent evaluation from the DV program, and then, yeah, they can put you in a halfway house to start you off.
Okay. All right.
Good
Thank
luck.
you. All right.
Good
Thank
luck
you.
to you.
Yep. Have a good day.
Okay, and they denied him, but surely he's going to be successful out there in the public. He's not going to be a harm to anybody. He's going to do fine. I know it. I can feel it. I think, as Dr. Grande says, if there is one thing for certain, it is that we will not see Mr. Bing Christopher Ortiz again.
My name is Bing Christopher Ortiz, 377-642.
Thank you. This is the public hearing, and public access to this hearing is available via video live stream. Present this morning, Attorney Jones, if you'd like to introduce yourself for the record.
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Ortiz.
Thank you. So, sir, this is a preliminary hearing which has three purposes under Connecticut law: to determine if there's a probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back out into parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you, and the hearing is also being recorded.
Okay.
The testimony in today's hearing is going to be taken under oath. So, Mr. Ortiz, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, upon penalty or perjury?
Yes.
Thank you. So first, I'm going to read your rights, then I'm going to review the parole violation charges the state and your parole officer is bringing against you. Then I'm going to review and identify exhibits filed for the record. The state is not present in today's proceedings. However, you will have an opportunity to address the issue of probable cause and severity of the allegations.
Okay.
At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. And do you have any questions about the purpose or the procedure before we begin?
No.
All right, thank you. So you have important rights to this hearing, which I'm going to go over with you now. You have a right to be represented by an attorney, and you do have one representing you here today. You have the right to receive written notice of the charges of the violation. Attorney Jones, was written notice received by your client?
Yes.
Thank you. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. The next hearing, you also have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand all these rights, sir?
Yes.
Thank you. So I'm now going to review the charges that the state and your parole officer is bringing against you and the information underlying each charge. So in regards to charge number 1, condition release direction, GPS, the charging officer reported that on 7/13/24, you had a GPS shutdown at 7/13/25 from 1:31 a.m. to 4:55 a.m. In regards to charge number 2, condition obey all laws, obedience to the law, the charging officer reported that you began your period of serious firearm offender per Public Act 23-53, adult probation on 5/31/24. You were instructed by your probation officer that you cannot have any unexcused absences from required programming. On 6/16/24, you missed your mental health medication management monitoring appointment at MCCA due to you violating the serious firearm offender adult probation requirements. A warrant was issued for VOP Connecticut General Statute 53A-32, and you were subsequently arrested and charged on 7/31/24. In regards to charge number 3, condition additional conditions, mental health evaluation and treatment as deemed necessary, the charging officer reported that on 6/16/24, you missed your required mental health medication management monitoring appointment at MCCA. So the state has also filed the following exhibits, which I remarked them as the state's exhibits for identification purposes. If Exhibit A, the remand to custody. Exhibit B, the parole conditions. Exhibit C, the notice of parole violation. Exhibit D, the parole violation report. Exhibit E, the GPS shutdown. Exhibit F, the arrest warrant. And Exhibit G, the GPS agreement form. Parole and Community Services also submitted an addendum to the PVR, which I'm going to be admitting into evidence and reads as follows. On 8/8/24, out of Derby Court, the parolee's charge of BOP Connecticut General Statute 53A-32 was disposed of, and the parolee's charge was nollied. Io Desena. Attorney Jones, did you receive the notice of the parole violation, the report, and all the other documents I just marked for identification purposes?
Yes, thank you.
Thank you. Do you need to continue this hearing to obtain any evidence on your client's behalf?
No,
And to my knowledge, we don't have any witnesses today, correct?
that's correct.
Thank you. So Attorney Jones, this is now your opportunity to respond and make a short statement, call any witnesses, and testify with respect to probable cause and severity of the allegations.
Okay, thank you. In regards to charge 1 GPS under release direction, we would submit there's insufficient evidence to support this charge, as the charge is written as alleging an impossibility, as indicating that my client had a GPS shutdown on a future date between 1:31 a.m. and 4:55 a.m. As charged, it says that his shutdown occurred on 7/13/2025. In regards to charge 2, the addendum was stated correctly. My client did have that matter pending in Derby Court, GA5. The matter was nollied. In regards to charge 3, under mental health evaluation and treatment as deemed necessary, it's alleging that on 6/16/24, he missed a required appointment. And I would just note that that was the basis for the violation of probation in court that was nollied. It was one appointment. I don't know if it was established or not that the appointment was actually missed, but the court, as well as the prosecution, felt as though missing one appointment was not worthy of proceeding with a violation of probation, and that matter was nollied. And I would just point out that it's not typical that a violation of probation is nollied in court. The typical procedure is that the client would have to admit to the violation, and he would simply continue on the probation with the same terms and conditions. And in this particular instance, the matter was actually nollied. So I'm just pointing that out in terms of mitigation. And if I can just proceed with the seriousness argument.
In a moment, I just would like to announce my findings.
Okay.
Thank you. Thank you. I was just taking some notes. So I'm going to notify you of my findings of probable cause time. On charge number 1, condition release direction GPS, did you make a finding of probable cause based on the evidence presented in support of the alleged violation? Attorney Jones, I do indicate the 7/13/25 date. However, I did note in the notice of parole violation that was issued to your client, the correct date is actually listed on 7/13/24. And I note that to the rest of the dates as a clerical error, but the correct date is listed on the notice of parole violation report. I also have a.
I was gonna say, if I could just also point out, though, at the same time, listed in the graduated interventions and sanctions section is also a 7/13/2025 date. And I'm just pointing that out because the evidence should be relied upon to support the charge. And if the charge is indicating a date in the future, then certainly the evidence that's relied upon is not accurate. And whether it's a Scribner's error or not, it doesn't support the charge as alleged. Thank you.
Yes, thank you. I do understand what you're saying, but the additional evidence that I do have provided, as I said, the correct date is listed in the notice that was provided to your client, and the additional evidence that I have provided does correspond with the correct date of 7/13/24. That evidence is Exhibit B, the parole conditions, Exhibit D, the parole violation report, Exhibit E, the GPS shutdown, which does reflect the correct date of 7/13/24. And I also have Exhibit G, the GPS agreement that was signed by the client. In regards to charge number 2, conditional bail laws, obedience to the law, I do make a finding of probable cause based on the evidence. Although the case was nollied, evidence provided and reviewed doesn't negate that the behavior did not occur. Also, I have Exhibits B, the parole conditions, Exhibit D, the parole violation report, and Exhibit F, the parole violation probation BOP arrest warrant that was provided into evidence. Additionally, on charge number 3, condition additional conditions, mental health evaluation and treatment deemed necessary, I did make a finding of probable cause based on the evidence presented, which included Exhibit B, the parole conditions, Exhibit D, the parole violation report, and again, Exhibit F, the probation BOP arrest warrant. Attorney Jones, if you would like to make any comments in regards to the seriousness and the nature of your client's case, you may do so now.
All right, thank you. My client was first released to community release, I believe, on April 18th of 2024. He then transitioned to special parole, I believe, on June 10th of 2024, and then obviously was remanded on July 31st. The nature of these violations that you just made a finding of probable cause on are one GPS violation in which my client was issued of graduated intervention and sanction regarding that conduct, and that was served successfully. 2 would be a violation of probation that was pending in court, and that was nollied. Because the court obviously did not, and the court, when the prosecution obviously did not feel as though any further incarceration or penalty in regards to a conviction on a violation of probation was appropriate, considering the violation as alleged was simply alleging one missed appointment. And then again, for the mental health evaluation and treatment, it's one missed appointment that's alleged there, that a finding of. I don't think that that's serious enough to warrant that my client remain incarcerated any longer. He has been incarcerated since July 31st, 2024 on that matter. And based on all of that, we would ask that he be re-paroled or reinstated to parole today. He does have a sponsor. He was living with his dad, and he was successfully living with his dad. And it's my understanding that his parole officer recently reached out to his dad and had discussions about him returning back to the home. So we are hoping that that can happen today. He indicates that he has an opportunity to work with a temp agency. It's unfortunate that he was working at Bizzuto's in Cheshire, but due to his background, criminal history, which I mean, I would think that they would have been aware of when they hired him, seeing that that's a employer that does work with parole clients, they did let him go. And that's noted in his parole violation report and substantiated by his parole officer. So I would just note that that's not due to any fault of his own. He's trying to actively engage in employment and be a working member of society. So with all of that being said, we certainly do not feel as though this is serious enough to warrant further detention and to go forward with revocation. We're asking that he be reinstated to parole today. Thank you.
Thank you. Attorney Jones, I just have a question in regards to your client. So there, in regards to the missed appointment on that one date, did he continue to attend or go back to MCCA for further programming?
Yes.
I mean, yes, and there's no indication that he didn't. And I would assume that if there wasn't any indication that he didn't, that those other dates would also be noted.
I went to 2 more groups after
And
that.
there's certainly no indication that he was unsuccessfully discharged, as we have no paperwork from that program indicating such.
Thank you. And the potential sponsor with the fathers is that he was sponsoring at before, is that the same address and information as prior?
Yes.
Thank you. So in regards to this case, I do find that the acts are not serious enough to warrant revocation. Sir, as such, your parole is going to be reinstated.
Okay.
The records office at this facility, as well as your parole officer, will be notified, and this does conclude the preliminary hearing. And I'm going to be going off the record. For the record, sir, just to note it, there is the knowledge charge, 1 missed appointment, and as you said today on the record, you did continue to attend MCCA despite having missed that 1 appointment. So, sir, as I said, your parole is going to be reinstated effective today. Okay.
Okay, thank you.
Yes. Do you have any
Thank you.
questions?
The only question I have is, so do I leave jail today?
Yes.
Yeah, you're on special parole, so you would leave effective today.
Okay, I thank you a lot. I appreciate you, Ms. Jones, too.
You're
Thank you
welcome.
both.
Good luck, sir.
All
Thank
right,
you. Good
thank
luck to you. This now
All right.
concludes the hearing, and I am going off the record.
All right, and I just want to point out that the attorney won the GPS infraction because the parole officer wrote the wrong date on the GPS, wrote 2025 instead of 2024, and that makes it invalid. And I always want to point out with these revocation hearings that they are like incredible. I think they're just, it's fascinating that it's an attorney appointed by the state for these parole revocationees, right? Against a probation officer. They're supposed to go up against an attorney, and these attorneys, they do their job well. Oh, you put the wrong thing in the date. Oh, you forgot that, blah, 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 and you don't get revoked. Instead, it comes down to just missing an appointment. And when you look at it that way, yeah, it's what's the big deal? But let's remember that the guy, his ankle monitor, it went off. He disappeared. He absconded. But as far as Connecticut is concerned, it's not a big deal. I don't have a lot of animosity towards the guy. He seems pleasant. He's nice, not a chomo. So you know what? I think let's give him a mulligan. If there's one thing for certain, I just know it. I just know it, as Dr. Grande would say. We will never see Mr. Bean Christopher Ortiz again.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. State, not you, responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of 1 or more conditions of your parole, I'll reinstate your parole, which release you, place you back on parole supervision. If I find you have violated 1 or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge state your appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find you violated 1 or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. Do you have any questions about the purpose or procedure before we begin, sir?
No.
Okay. Your important rights today, your right to have an attorney present. You have counsel here. Your right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine diverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so we now review the charge the state appeal is bringing against you and the information underlying each charge. Appeal to see enough, you could please read the charge.
Hello, sorry, my phone cut out.
That's okay.
All right, so obey all laws, A, obedience to law. On August 22nd, 2024, you're involved in a motor vehicle collision where you caused damage to another vehicle.
Okay.
So driving without your parole officer's permission, you don't have a license, suspended, right? So you have to get that straightened out, add it to your list.
After the crash, you fled on foot to elude the police and were subsequently apprehended by Milford police after multiple agencies were looking for you. You're arrested by Troop G for the charges of evading responsibility and following too close.
Thank you. And the state has filed the following exhibits pre-marked for identification purposes. Exhibit A, remain in custody. B, parole condition. C, notice of parole violation report. D, parole violation report. E is Connecticut State Police Criminal Information Summary. And F is State of Connecticut Judicial website showing court date. Did you receive notice of parole violation report, and those other documents I marked? And did you review them, sir?
Yes.
Okay. And counsel has filed the following exhibit that's pre-marked for identification purposes. That's Defense Exhibit 1. List of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
We have no witnesses today. So at this time, well, before that, I will put on the record that I did receive an addendum. The addendum stated on 9/20/2024, all charges were nollied. So now at this time, the state will have an opportunity to call witnesses, present evidence, speak to any of the evidence at this time. I'm going to swear you both in case you both speak. So Mr. Ortiz and P.O. Cristina, can you please raise your right hand? You solemnly swear, sincerely affirm, as the case may be, the evidence you shall give during this case to be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Yeah.
So P.O. Cristina, would you like to say anything at this time regarding the charge?
Regarding this charge, no, just in the fact that, you know, he was arrested only being out for a few days back out in the community from a previous violation from a VOP violation of probation. So, I mean, that's all really I can say. I know I was nollied, but he was arrested. You know, the crime did occur. So that's all I have to say.
Thank you. And then I'm turning over to counsel right now.
Yes, thank you. We would submit there's insufficient evidence to support the charge, namely, following too closely is an infraction. It's not a crime. And evading responsibility in regards to that charge, it was nollied in court. It's an on-site arrest. My client remained on scene. However, he was standing several feet away from the incident. He did not evade the scene. He remained there. That was the basis, is my understanding of why a nollie was entered in court.
All right, so I'm gonna be right with you with my findings. So regarding that charge one, I do find you violated obedience to the law, the charge of evading responsibility based on the evidence provided in support of the charge, exhibits B, D, and E. So although the charge is nollies, I find behavior meets the elements of the offense. I do make a no finding on the infraction of following too close, because it does not meet the elements of that charge. That concludes the fact finding portion of this hearing. Before I make recommendation, counsel will have the state will have an opportunity to speak to you back on history, and after the state is finished, so will counsel. This purpose part of the hearing is to help determine what outcome I will recommend. So, P.O. Cristina would like to say anything at this time regarding the second part of the hearing.
Thank you.
All right, thank you. So, counsel would like to say anything?
Yes, thank you. My client is 32 years of age. He is single. He does have a 5-year-old who resides in the Waterbury area with his mother. He does have his GED. He successfully completed New England Tractor Trailer Training School.
You are trash.
So he does hold a CDL license that does need, is in need of renewal at this time. He does live with both substance abuse as well as mental health issues. And again, in regards to the criminal violation, he does maintain that he didn't run from the police, that he remained on the scene. He was standing approximately 30 feet away. It was an on-site arrest, and he was arrested within 15 minutes of the incident. I would just note that in the recommendation section, his parole officer was recommending a sanction based on the fact that there was no sanction at his last violation hearing. And I would just point out that my client did not receive a sanction at his last hearing simply because there was a no finding made, which was indicative of the state not meeting its burden of proof. And therefore, he was reinstated to parole supervision. When he is released back into the community, he is indicating that he would like to be sponsored. Let me just confirm by his friend, and her information is contained within Defense Exhibit 1. As a backup, he was indicating that he would like to be placed in a halfway house in the Haven area. He does have a work history. He was working at FHI in Cheshire, working at FHI as well as Pseudos in Cheshire. He did lose that job at one point due to his criminal history. But certainly he is amenable to all employment opportunities. He's indicating that he can gain employment through a temp agency in the Waterbury area as well. And I would just point out this is his first violation of this period of supervision. Thank you. We would be asking for reinstatement at the next available date.
All right, so I'm gonna be right with you with my recommendation. So I have you all guys. So defender was outside the community for 2 days prior to being returned to custody. He does have a prior violation, and there was a finding. He was reinstated and determined it was not serious enough. However, that he does have a prior violation as well as 2 prior community release failures. The offender should not be operating a motor vehicle and was found to be operating a motor vehicle, which led to this incident that was nollied. Based on this information, I am going to recommend that parole be revoked and that you be reparoled for December 20th of 2024. This is about a 4-month period of confinement as a sanction. I recommend the following parole conditions: no contact with co-defendant Carlos Lopez, mental health evaluation and treatment as deemed necessary, behavior management program for domestic violence, no contact with your victim BG without PO's permission, as well as operation of a motor vehicle, which means you are not to operate a motor vehicle without permission from your parole officer. Do you understand that?
Yes, I have permission that time though. She's there on the phone. She could tell you she gave me permission. I have my license.
Well, that's probably why you weren't charged with it, but I'm just saying, make sure you know you should have permission to drive, okay? Because it's leading to some trouble for you. So the board, I'm going to present this to the parole board on November 7th. So the board's going to review it. They can lessen it. They can keep it the same, or they can impose a sanction longer than what I've recommended. If they want a longer sanction than what I've recommended, you'd have a supplemental hearing. And before the hearing, the board would provide you with written notice documenting the reason why they want to exceed my recommendation. During that hearing, you would have an opportunity to respond to those reasons while in front of the panel. So this is just a recommendation. You will know what the board's decision is after November 7th.
Okay.
Do you understand?
Yes.
Okay. So you are all set for today, sir.
All right. Thank you. And thank you, Sonia.
Good luck.
Thank you, Christina.
Thank you.
Have a good day.
Okay, and there you have it, a 4-month sanction, and that's all it was. And as of today, June 15, 2025, he still is out on special parole. It seems that he's in. It seems that he's at a halfway house, from what his record here shows. And isn't it funny? I mean, isn't it funny how they even bring up? They're like, "Oh, well, the prior revocation, there was a no finding." And again, remember, you took his GPS angle up, but you can't can't get it. No, it's up because you put the wrong date in. And then they're talking about here how, oh, you were driving. Oh, no, I was okay. My parole officer said I could drive. I would have loved. Do you have a license? Like, remember, we know this from watching revocation hearings in other states. Like the ADAs, they now cross these things all the time. You know why? Because they assume that the parole revocation unit is going to do their work. They don't need to prosecute someone when someone's out on parole. That person, they get cuffed. They go straight to prison. They don't have the due process of whatnot. You can't bail out. No, you violated your parole conditions. Now you got to have the preliminary hearing. You got to meet with the parole revocation board, and the DAs know that, so they null cross. That's how it works. But in like Connecticut, it's like, no, he was caught 15 minutes away. He didn't like. You left the scene of the accident, please. Please, you don't get a hit and run because you walked away from the car to have a cigarette break. Anyways, I mean, the whole thing is crazy. The guy's, it's like you don't have so much animosity towards him. He's not rude, but also remember what got him locked up to begin with. What was it, like 3 possession of a weapon charges? How long is his record? I do predict that we will see him again. Not today. I'm not going to tease you like that. But I do predict that we'll see him again because he has special parole up until 5/31/2027. And it's like expecting different results, the whole Einstein quote thing. I mean, this guy's record is long. I can go over what Sir Richard found. But talking about Sir Richard and Lady Holly, of course, I mean, the reason that we're able to keep track of these inmates is because of the spreadsheets, because of the work. I think we're the only YouTube channel that does this, that keeps track. I'm sure there are others that do it, but like for parole hearings at least, right? And we do this because it's telling a story. It's telling a story that simply data can't tell. Because I would, Connecticut would paint, I bet you, this story very differently. They would say that their progressive approach to corrections is earth-shattering. It's changed. Look at this. And they would bring up that, well, here's someone with a long criminal record. We got out here and we got him a trucker license, which is absolutely insane. I am sick and tired of Connecticut giving CDL licenses to people who shouldn't even be driving. We see it being given to people with DUIs. We see it being given to chomos. We see the CDL licenses being given out like hotcakes. And God, let's not go down that road. I have no doubt that it is some very large 7-figure contract that was signed with this trucking company and other people. Ooh, let's give you a multi-million-dollar contract to teach inmates how to drive trucks, because that makes sense. Who cares if they have a suspended license and accidents and violations and aren't even allowed to drive? Let's give him a license. Oh, let's give a chomo a license so he can drive cross-state. And what's the big deal? I mean, who cares, right? Let's give the guy with habitual DUIs a CDL license. We don't have PhDs. We don't understand. But if you just need to, right? It's a money-making scheme. That CDL truck driving lesson thing, they're making millions of dollars teaching people. It's blah, 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 blah. Anyways, I digress, right? I lost track. I think we all get the point. What I was saying is that, again, Connecticut would probably say, look, here's someone who got locked up. What? He had a small infraction. It was an infraction for not showing up for a medical thing. Please. No, we know what actually happened. He absconded. But because of a technicality, because Connecticut gives attorneys to everybody, be here, attorney for you. In Louisiana, no. Louisiana, I don't know what you need to do to get an attorney, frankly. I mean, we've never seen them hand out attorneys. You have to be like, I don't know, Jesus or something to get an attorney from Louisiana. But it's not necessary in Connecticut. Everyone gets one. And when you're up against a parole officer who's overwhelmed, probably underpaid, overworked, underappreciated, you want to talk about the unsung heroes. It's like, everybody, thank you for your work. But a probation officer, they literally are walking around with a bulletproof vest and a gun on, but they don't get the respect that police get. And they have arresting, but they got to deal with this drama. And then they have to act like an attorney. No wonder there's a typo in the year. Anyways, Let's see his long record. And for those of you in the comments section, say, I don't want to hear you talk. Just tell me the crime. It's like literally, I show you an hour of hearings and then you hear me talk for 10 minutes. And if you don't want to hear me talk, shut up, YouTube. That's the thing. I don't get it. I really don't. I get it too. The reason that I do the YouTube channel in the style that I do it is because I don't like hearing YouTubers talk over stuff. And that's why I don't talk over stuff. But at some point, I'm going to talk. And if you don't want to hear it, then shut off the channel. But why are you commenting it? It's nuts. Is it not nuts? It's nuts. Like, what? Okay. Ooh. All right, 427. We're going over his record. 2015 assault of a public safety. He's not a nice guy. Assault. Yeah, 3 months jail. 418 2019, because apparently, okay, this is breach of peace. 10-1 2018 assault third. And by the way, you'll see all these suspended sentences, which is how it works. You get suspended sentences that they never have to serve. 8-4 2021, stealing a firearm. That's a nice guy. Sentence 3 years, special parole 3. Criminal possession of a revolver. Arrested 7-18 2022. Assault again. 2-17 2021. Run from police, injury, or death. What's that? Did he kill someone? Resulting in injury or maybe it's injury or death. Okay, could be death. Illegal possession of a weapon in motor vehicle, 1-3-20. I mean, the guy has such a long record. 5 years suspended after 3 months. Here he is in 2021, a 5-year sentence suspended after 3 months. And let's keep in mind that his entire bloody sentence for this, what was his entire sentence again? Up here. His entire sentence, I didn't copy paste it, but we know that it wasn't even like this is the gimmick of suspended sentences. It's just a gimmick. They almost never serve the time. Reckless endangerment, 2nd degree, arrested 10-26-2020, assault 3rd degree. The guy is a menace. 14-13-2021, criminal mischief, violation of protection order, and it just goes on and on and on and on and on. And Connecticut will probably deem this thing is working, but no, it's clearly not. He's dangerous. Every moment he's out is dangerous. He's not rehabilitated. He's not better. He's not over finished his criminal career, and I think it's probably going to be another serious crime, and we'll see him back. But that's just my thoughts. What are yours? And if you want to see more hearings like this, where we connect the dots with the spreadsheets and we keep track, go to the return of playlist. And if you don't want to see me talk, you know what? Let me know in the comments section. I'm here for it. And with that, I'll let you go.
So, Mr. Ortiz, you must understand our dilemma. You're a very high risk, right? Given that it's your third gun conviction. You were on probation at the time for a robbery first. These tickets are very serious, but we want to recognize that it sounds like you're on the right path. You have some new insight. You've grown and matured while you're in there.